Okay, just one hot minute and we're almost there.
Good morning, everyone. Thank you for joining us for the most exciting part of the State Bar's annual meeting, which is our annual business meeting. And we do conduct some important business at this meeting, so I thank you all for joining us. So I'm going to say a few words about the state of the bar. And the first thing I would like to say is that we are alive and well. And for those of you who followed everything that was going on in the past year, that was no small feat. And I need to thank everyone who was part of that effort, starting with our extremely competent, capable, and faithful Executive Director John Mudd, our lobbyist Bruce Spencer, the Executive Committee, and others who you'll hear about later today. But we are alive and well, and for the first time ever, the State Bar will be publishing an annual report. You all will be receiving it via email in the next few weeks. Credit goes to John Mudd and Lindsay Metzger, our Communications Director, for pulling that together. And I'd like to share with you some statistics from that report. So like I said, this will be in your email inbox soon. It will also be posted to the State Bar website. First, the bar by the numbers. We have about 4,200 active attorneys, about 32 of whom live and practice in Montana. So that means we have about 1,000 admitted and active attorneys who are out of state. We have 22 practice area sections, and then about 15 State Bar committees. In terms of growth, the overall growth in the number of active Montana admitted attorneys was about 100. Also, the number of Montana-based attorneys grew by about 100. Number of out-of-state attorneys grew by about 50. And an interesting trend here in terms of gender, the number of female attorneys increased by 6%, which was 3 times as fast as the number of male attorneys. So that's kind of an interesting statistic there. And then in terms of district growth, the district that saw the greatest number of growth in its attorneys was Kalispell. And so we took a look at that earlier, about a year ago. Every 10 years, we need to look at the allocation of state bar trustees, and we took a look at that given the demographic changes. That's an interesting challenge, but the state bar does revisit the allocation of trustees at least once every 10 years. And then in terms of section increases, we saw the greatest increases in the better law section, followed by public utilities, Indian law, and family law. In terms of finances, you're going to hear more about this from our treasurer here shortly, but this thanks again to the excellent stewardship of John Mudd. The state bar is in great financial condition, and I know that was a turnaround from several years ago. We're grateful for that. The last dues increase was in 2018. We do not anticipate petitioning the Supreme Court for any dues increases in the near future. So that should be good news to our membership as well. As you heard yesterday, Montana attorneys devoted about $17 million worth of time in pro bono services over the course of the last year. And then the annual report is also going to talk about several other state bar initiatives, many of which you've already heard about. I'll just list some of them here. Law School for Legislators, which I participated in January, high school mock trial competition, Citizens Law School, the Licensed Lawyer Program, the Task Force on the Future of the Legal Profession, Lawyers Fund for Client Protection, and the Fee Arbitration Program. And then the State Bar continues to focus on the delivery of high-quality continuing legal education programs. I started my State Bar career with the CLE Institute, and I'm currently serving on it again. So that's a particular endeavor that I intend to continue with. And just on that note, I'd like to give a nod to Mike Larson. Is Mike? Where's Mike? There he is. And the work he does with the Lawyers Assistance Program. We had close to 1,000 attendees to a CLE program that he put on in March and April of this year. So that program is extremely valuable to us and to our membership. And Mike continues to put a great deal of his time into those efforts. So that is a high-level summary of our annual report. And again, the state of the bar is alive and well. We're in excellent financial condition, and we continue to grow. So with that, I'll turn the floor over to Erica.
Good morning. I think I know most of you in the room. For those I don't, I'm Erica Grindy, Secretary-Treasurer of the Bar. First, I want to thank all of you and those members who aren't here for allowing me to continue to serve in this role, and also to congratulate Tony and our entire board on a really, really good year. As you've heard, if you've been here for the full meeting, it wasn't short on challenges, but Tony led with courage and certainly made it a year for me and hopefully the full board and executive committee to be very proud of what we've done. Next, I just want to highlight the State Bar staff, both for this meeting, along with, as Tony said, the work of John in leading this organization in such an admirable way. Specific to the work I do, I get the opportunity to work pretty closely with the Director of Finance and Operations, Jill Lloyd. Jill's not often in these rooms, but I just want to tell all of you members that we are so very fortunate to have the skills of Jill Lloyd. And serving in my role, Jill makes me look good. She sends information, she's always available, she always has answers when I dig into the numbers. And my day job, I spend a lot of time with numbers. I think initially Jill might have been a little bit worried to have me serve in this role because I actually enjoy looking at audits and asking questions. But I'm really enjoying working with her and really enjoying the relationship that she and I have have built. So just want to call her out and just to say thanks for her leadership in terms of the finances of the organization. So how are we doing? You heard from Tony, the organization is doing quite well financially. And absolutely, a lot of that is due to the leadership that John has brought to the organization. You've heard this before if you've attended these. Part of that is also due to the pandemic. We do business a little bit differently these days, including at this meeting. We're able to have members attend these virtually. Our revenue for CLEAS, including the annual meeting, has really improved because we're able to deliver services virtually as well as in person. So we're sitting with about $6 million in our investments, and I think someone during our board meeting said, the rich get richer. So when you have that kind of money sitting in your investments, our investment revenues continue to grow. That is a really good thing, and it does allow us to be in this position, as Tony said, where we're not looking and we're not talking about in board meetings dues increases, and that's good news. The flip side of that is, for those who don't know, my day job is in local government, and the similarity there is we want to make sure we're also spending those assets to move this organization in the direction of achieving the goals that we've set for ourselves. And so I think that's really the direction that you'll see the board moving. I think that's the direction that John is really looking to guide us towards. And so given the present financial position, we won't be seeing dues increase, but we do look forward to investing in meeting our mission. And I have not memorized that mission, and I think everyone on the board is working towards this because we just established it. So I'll read it again. Continue investing in the profession to continue the mission of promoting the highest standards of professionalism and competence in the practice of law to foster an accessible, fair, and independent legal system and preserve the rule of law. I look forward to working with Iceland and the executive committee, continuing to work with the staff in terms of the finances and operations day to day, and really look forward to reporting to all of you throughout the next year how we are using those assets to move us closer to those goals. And I think John will dive into some of the specifics of where we're investing those at the present time. But happy to take any questions if anyone has also dug into the numbers and attempt to answer. All right, thank you.
Good morning. They always tell you never follow a better speaker, so I get to follow two of them. I'm Rich Batterman. I am the, I guess, soon-to-be outgoing, I'm not sure what my status is, but the last year I was the chairman of the Board of Trustees for the bar. It was my privilege to work with probably the most dynamic and talented group of people I've ever had that opportunity to do. What can I tell you? The trustees are primarily the tip of the spear, right? We are your representatives across the state. Obviously, they all work in their individual districts in terms of delivering the bar program to the membership, and then by extension, making our profession a stronger one in our communities. I think we had a good year. The group really engaged, as they always do, with their constituents. We had some real success in activating some local bars that really hadn't been particularly active in my own area, Area E, which is, surprise, surprise, eastern Montana. The Sydney Bar, the Northeast Bar Association in particular, really got very active in terms of all things attorney recruitment, and made some strong inroads with the North Dakota School of Law. Of course, Helena and Missoula and Bozeman and Kalispell all remain particularly active areas, as does Billings, our largest single area. I'm very proud to report that our trustees remained active through what was perhaps one of the most challenging legislative sessions in recent memory. Shout out to John and to the executive committee. Did a fabulous job organizing, but the trustees really engaged with folks across the state to deliver our message that an independent profession is essential to the function of proper government and ultimately to our state. And I'd like to particularly recognize Trustee Eli Patton for all of his hard work and his firm's hard work. The Crowley firm was very, very supportive of the bar's activities in the legislative session this year. So thank you, Eli. I hope if there is a legacy to be left, I'm not so ego-driven as to think it's mine, but I hope that this year the Board of Trustees in its annual planning session has really set a high bar for the profession. We've set an ambitious series of goals that we hope will enhance the future of the practice of law in the state of Montana, as well as grow our partnerships with not only our governmental representatives, but also our clients and our professional associates across the state. The trustees were engaged, they were active, they did a fabulous job, and I think they have set the bar on a very positive path to the future. So it has been my privilege to serve you as your board chair. I'm proud to hand off to Anna, who will be the incoming chairman of the board, and I look forward to working with Aislinn, John, Tony, and the others moving through the leadership board, or through the leadership positions. Your trustees are doing fabulous work. If you haven't thanked them, do me a favor, pull them to the side and express your gratitude for their commitment to making our profession a better one, because they really dedicate a lot of time and effort. So if there are no questions, I appreciate you all getting up early, getting a free breakfast, and listening to me drone on. Have a wonderful day.
Sorry, it's a coffee kind of morning here. Well, good morning, everybody. For those of you who don't know me, I'm John Mudd, Executive Director of the State Bar. It's my privilege to be in that role. This is my 8th, I think, annual meeting as Executive Director. Just a couple things I'll go over from an operational standpoint. We were just talking about the legislative session. As some of you know, we do a refund to members who may object to any of the positions we take. This year we had what we believe was somebody who had used a mailing list that was a bar mailing list and sent something to all the lawyers and judges in the state, sort of maligning what the bar was doing and noting that you could get a refund if you didn't like what the bar was doing. I believe that went to everybody on our active attorney list. And so I just wanted to let you know, we typically get 5 or 6 objections a year. This year we got more, like 20 or something like that. But we paid out $550 in $17 increments, and we actually had people send us money because they liked what we were doing, and that was about $450. So we actually came out better than normal. We were not sure how that would go, but I also think it shows that really, even when something was sent to every member in the state, most lawyers are comfortable with what the state bar is doing legislatively, and we don't get too far outside our lane. We can't. We have to only take positions on things that are germane to the purposes of the bar. So, and thank you to Bruce and to Eli and Tony and everyone who was involved in that. Let me just give you a little bit of where we are operationally, because I think probably most folks don't have a sense of the size of the organization or anything like that. We have 13 staff, and we operate in kind of a structure of I'm the executive director, Mike serves as both LAP and as the deputy executive director. Jill Lloyd, who is here somewhere in the building, is our director of finance and operations. And then we have two significant departments. One is our MCLE, that's our compliance department. That's headed by Jennifer Rickman, and she has two people under her, Holly Bixby and Bettina Naylor. They are the people who are doing your CLE compliance. They're reviewing your uploaded documents and approving that. And then we also have, on the admissions side, we have Kathy Lynch and Missy, and they are the two people who do the admissions work. And so that's, and the way that works is there's obviously two commissions of the Supreme Court, the Board of Bar Examiners and the Character and Fitness Commission. And we do that staffing work for those commissions and do the admissions side of things, administering the bar exam. The commissions make the ultimate decisions because they are under the court, but we provide all the staff support. Same on the MCLE side. There's the Commission on Continuing Legal Education, which is a Montana Supreme Court commission. Our staff handle all of the routine staffing of MCLE. And then we also have Aural, and he's running around here somewhere. He is our IT person. He is full-time with us. And we have, of course, Jill Dively. Many of you know Jill. Jill handles membership. She's also our board governance coordinator. She's also my person who tries to herd me. And then we also have Regina Mercado. She is a paralegal. She helps us with the Lawyers Fund for Client Protection, the fee arbitration program. We monitor IOLTA overdrafts. And she helps with any legal matters that we sometimes have. And then we have Ann Goldishian. She is our Equal Justice Coordinator and is also involved with the fee arbitration program and the Lawyers Fund for Client Protection. I think I got everybody on that list. So it's a very busy operation and probably bigger than most people realize. A lot of it is kind of running programs that the Supreme Court asks us to run, like the fee arbitration program, Lawyers Fund for Client Protection, and so forth. So one of our priorities is obviously operational continuity and enhancement. We went through a transition several years ago where we had a lot of longtime people. People may remember Gino. Gino was at the bar for 30 some odd years. So we have some longtime employees and we recognize they will not always be with us. So one of our priorities is really working on operational continuity. And then the other thing that we're trying to make sure that we don't get into a situation with is too much technology debt. And I don't mean actual debt, but getting behind on technology. One of the major investments over the last several years has been in technology. And so we tried very hard to make our systems all talk to each other. About 8 years ago, none of our systems talked very well together. So we made a major investment into our back-end technology. You don't see most of that, but that is our database. We actually maintain the attorney database that is the official database. We upload that to the Supreme Court every night. So because we're making changes, people may not pay dues, people may get suspended. That information actually flows not from the court to us, but from us to the court. So every night there's an upload on the attorney file so that if somebody has been suspended for not paying their dues, then also like their access to electronic filing and those kinds of things changes. And so we do all of that work. We are right now investing in our website. And so in the next couple of weeks, along with the annual report that will be coming out, we'll be turning on a new website. It's not going to look dramatically different, but we've reorganized it in a lot of ways that we think will be better for both the members of the bar and for the public. And then, as part of this, making sure you're not getting into too much technology debt and making sure you're keeping up with things, we're going to do a major enterprise risk assessment over the next 2 years. And that looks like, from an enterprise risk management standpoint, looking at all the operations of the bar, deciding where there may be operational risk, One of the things we handle is a lot of confidential information, particularly on the admissions side, and looking at all of those kinds of things, both from a security risk standpoint, also operational risk and continuity. What if one of us gets hit by a bus? What do we do then? And sort of trying to make sure we've got a good plan for all of that. And then what I would say just on the investment and the money side is we work with an investment advisor, Ashton Thomas. They have been our investment advisor, Scott Knutson, for 25 years or so. And so we operate in a way that we have a net operating revenue situation. So we're continuing right now to put that money into investments. It's invested very conservatively. But when you start to say about $6 million and you say 3 or 4%, you can realize that that is continuing to grow, and we're adding into that every year because we're running the operation lean. This year so far, we've had about $330,000 of unrealized investment gain. So when you start talking about, okay, well, we're going to make a technology investment, we're going to make strategic investments, we have the money to do that because our investments are making money that allow us to do that. And then we're continuing to make sure that structurally, year to year, we're operating in a net operating revenue and not a deficit standpoint. The other side of that too is we haven't had a dues increase since 2018. What that means is if we've got money in the bank here and our expenses start to catch up with inflation and so forth, we have reserves that are sufficient for us to keep that going for a long time without needing a dues increase. At the 2018 dues increase, we told the Supreme Court we thought it would be probably FY23 or FY24. We're obviously now into FY26. We don't see any need right now I would say in the next 3 or 4 years, certainly, for any sort of dues increase. ODC has never had a fee increase. So, and that was the same thing that happened with MCLE. You'll remember MCLE fee went up from $20 to $40. They hadn't had an increase in that operational fee for 20 years. And disciplinary counsel has never had an operational increase since that unit was formed. So they may need something. And all of that stuff is a consolidated budget that the trustees review. Trustees cannot make any changes to ODC's budget. They just have to review it as presented. But we are all under the same EIN. We're all under the state bar as an operational unit. Everybody's an employee of the state bar, which, as you all know, is not a state agency. Most people in the public call and they say, well, you're a state agency. Like we receive 0 state appropriated dollars for our operations. It's all based on what the attorneys pay and our program revenue. So that's kind of an overall view. I think, as Erica mentioned, the operations are in a structurally sustainable place. We always look to say, do we have the right mix of people? Do we need to add some people? We use some external, both consultants to help us with various things. So we're doing a lot of HR work right now in terms of our team and trying to make sure we continue to invest and build our team. We use external folks to help us with strategic planning. And we also have some contracted services. Our communications is a contracted service right now. So we have a person who's worked in Washington, D.C. with associations for 25 years. She's a Montanan. She lives here. And so she helps us with a lot of our external communications. But we're able to do some of those kinds of things with consultants so we don't take on additional staff, which helps us from a budgetary standpoint with benefits and so forth. And on that last note, we really have tried throughout the pandemic and also throughout an increasing inflationary environment not to have to pass along costs in terms of increased healthcare or things like that to our staff. So we've continued to make sure our staff are paid a competitive rate. And we continue to do market analysis on all that and make investments into benefits and absorb costs and increase there so that we retain people. So I'm pleased with where things are, and I'm happy to answer any questions, but that will be sort of your summary of the day-to-day operations. So thank you very much.
Good morning, all. Rich said that he was going to read my 800-page ABA report on Wednesday, so instead of addressing you all, I'm going to do a pop quiz here, Mr. Batterman. For those of you who don't know me, my name is Tucker Gannett. I'm the State Bar's representative to the ABA's House of Delegates. The ABA is the oldest professional organization for lawyers, founded in 1878. The mission of the American Bar Association is to improve the justice system, set standards, and provide resources to its members and the public. The House of Delegates is the policymaking body of the American Bar Association, comprised of 546 lawyers from across the nation. The Montana State Bar has sent a delegation to the ABA's House of Delegates since 1975, so that's a full 50 years. The current delegation for Montana consists of Bob Carlson, former ABA president and lifetime member of the House, Matt Teal, our state representative, Michael Kleperick, the Young Lawyers representative, and the State Bar's Secretary-Treasurer, Erica Grindy, was recently voted onto the Board of Governors. The House of Delegates meets twice annually to meet the needs of the profession and the needs of the moment. This was a little bit of an unusual year in the House. There has been more government interest in the judicial branch of government here lately. In the mid-year meeting in February, the House took up matters related to courthouse security. This is an issue that is important across the country. Your State Bar of Montana, in its infinite wisdom, took this issue up here a few years ago. But there was a resolution passed in the House urging state and local governments to create security task forces to evaluate security needs in the courthouses across the country. That resolution was adopted. There was a companion resolution protecting the privacy of judges and their staffs. Private information, telephone number, addresses. There were a lot of threats on the judiciary in the last 12 to 18 months. The House in February also passed a resolution urging the U.S. Supreme Court to have a binding code of ethical conduct. The Supreme Court responded to an earlier resolution. They adopted a code of ethics, but they made following it voluntary. In the annual meeting, which was just here about a month ago, we had, again, unusual circumstances. The federal government had targeted certain law firms and lawyers for advocating for clients that the administration viewed as hostile. So the House in August took up resolutions opposing efforts by the government to punish or threaten lawyers or law firms for representing clients that the administration views as hostile. That resolution was passed. There was also a lawsuit filed by the ABA in June seeking to promote the rule of law and the independence of the judiciary. There are a number of other resolutions. If you look at the report, there were something like 75 resolutions that were considered by the House over the 2 days here in August. Again, a written report has been submitted. For those of you like Mr. Batterman who are so curious, you can read that. It's on the State Bar's website. Also, if you have any questions about what's going on in the ABA, feel free to approach me or any of the other ABA delegates. Thank you very much.
Our chair of our past presidents committee is very much past, so he is not here this morning. The past presidents committee, as you know, but as you may not know, meets annually mainly to review the submissions for our resolutions, which we'll have here this morning, and then also to do the awards. And I think Tony is looking to actually expand and kind of reinvigorate our use of our past presidents in ways that will be beneficial to the organization. And so that will be my report in place of Stu. I've never been a president, but since Stu isn't here, and I'll just shift right into Two things. Number one, on your agenda, it says the Distinguished Service Awards used to be during the business meeting. We're going to push those to lunch. So those will be given out about 11:30 as we head into our CLE that starts at noon today. So that's just a little agenda adjustment that was still on there as being taking place this morning. Let me just tell you on terms of Lawyers Fund for Client Protection, and this is a fund. It was called the Client Security Fund initially when the bar was formed. We run that claims process, and what that is different than a fee arbitration. In order for a claim to be deemed valid to the Lawyers Fund for Client Protection, it has to be based on the dishonest conduct of the lawyer. The lawyer has to be disbarred or disciplined or suspended. Or in some cases, the lawyer's deceased. It's different than a fee dispute. And sometimes that is the committee, the board that manages the fund. The trustees are technically, it's a trust under their direction. They have a appointed Lawyers Fund for Client Protection board that reviews all those claims. And so it's a little bit like a court, if you will, where we receive an application, there is an investigation, or if the lawyer has already been subject to public discipline, we will get the investigative materials from the Office of Disciplinary Counsel, make an assessment, and then, and again, that would only be in the case where there's public discipline and that information is public. But during the period of January 2023 to January 2025, this will be in our annual report, there were 17 new claims filed, 15 were approved, and 2 remain under review. And then payments of about $131,000. During the last year, most of that had to deal with the McEwen Dowd case, and Megan Dowd, who was disbarred by the Supreme Court. And we paid about over $100,000 to some of the claimants there. And we were fortunately able to, with Matt Teal and Bruce Spencer's help, the board and the trustees were able to go enforce the judgment of the Supreme Court. And actually there was a sale of a home, and we were able to step in, file those pendants, and get it 130 or 110,000, I think, in some change. It was 114,000 back. So the fund was partially made whole, well, fully made whole to date on the claims that were paid related to the Dowd disbarment. So that was some good news. We also got some money out of an estate of a deceased lawyer that we had paid out. So we've been aggressive about, when we can, trying to make sure that the restitution obligation that all lawyers have is enforced and that the fund is made whole. So that's the report on the Lawyers Fund for Client Protection. Any questions? Okay, thank you. We're going to take just a minute here so we can make sure that the resolutions are available, and we'll do a poll for anybody who's online, if we have anybody online. Errol, is anybody on the stream? Okay. This is the downside of having a partially virtual business meeting, is that we have to be able to have folks vote on the resolutions. While we have a minute here, if we could just, I don't know if there's anybody from the law school still in here. They're going to be doing their law school update here in just a couple minutes in the other room. But want to thank the law school. They sponsor this breakfast every year, and we remain very engaged with them. And I think we now have several officers who sit ex officio along with myself on the Board of Visitors over there. So we try to maintain an open dialogue with the law school. Some of you saw that we were doing our task force on the future of the profession discussion yesterday. When we surveyed the members, we received input from the law school on questions that they wanted to ask as they were doing their own strategic planning to make sure that they're teaching the kinds of things that the members of the bar find to be necessary to continue to enhance the practice of law and improve the quality of legal services delivered to Montanans. I'll go ahead and just, Errol, are we ready to? Okay, well, that's a problem. Well, let's do it this way. I'm going to go ahead and read these out, and then if you can just, if you're online and watching this, if you can just. Yep. Okay, so I'm going to read the first resolution, and then we will vote on it. This is a resolution that is probably familiar to some of you. It says, whereas the State Bar of Montana has proudly supported Montana Legal Services Association since its founding in 1966, and whereas nearly 1 in 5 Montanans qualify for legal services through the Montana Legal Services Association based on income and asset eligibility, and whereas the State Bar collaborates closely with Montana Legal Services Association and the Montana Supreme Court's Access to Justice Commission and many other partners to strengthen access to justice across the state, and whereas Montana's judiciary has shown leadership and commitment by supporting effective and innovative programs for both pro bono and self-represented litigants, and whereas private attorneys across Montana have consistently stepped up to meet the critical legal needs of people experiencing poverty, and whereas despite the dedication of private attorneys and the strength of Montana Legal Services Association's statewide service model, the legal needs of low-income Montanans still significantly outpace available resources. Now, therefore, be it resolved that the State Bar of Montana convene in Helena for its annual meeting on the 12th day of September 2025, hereby strongly encourages Congress to renew and uphold firm national commitment to equal justice for those living in poverty as envisioned in the Legal Services Corporation Act of 1974, and strongly advocates for increased federal funding for legal aid programs nationwide, particularly during this time of heightened demand, and strongly calls on all members of the State Bar of Montana to actively engage in pro bono initiatives organized through collaboration between the bar, local associations, Montana Legal Services Association, and other access to justice partners to help ensure legal services are available to those who cannot afford them. And so that is resolution number 1. Hopefully those of you online could hear that. If you don't have it, it should be posted on the website in the annual meeting documents. So we'll go ahead and, I guess, call for a vote. And if somebody wants to move adoption of that resolution number 1. Any discussion? Okay, all those in favor say aye. Aye. Any opposed? And online? Okay. The membership present at the business meeting in 2025 has adopted resolution number 1. Proposed resolution number 2, submitted for consideration to the Past Presidents Committee by the Board of Trustees of the State Bar of Montana for a vote of the membership, whereas preparations for the 2025 annual meeting of the State Bar of Montana, this is where it's good to have been the Secretary of the Senate, where you have to read this, entailed countless hours of time and effort by the attorneys and judges in the Helena area, the members of the First Judicial District Bar Association, the Area F trustees, and officers of the State Bar at the meeting and the meeting sponsors and others, and whereas the 2025 annual meeting would not have been possible without the generous contributions of time and talent donated by those individuals and entities, now therefore be it resolved that the State Bar of Montana does hereby express its deepest appreciation to attorneys and judges of the Helena area, the members of the First Judicial District Bar Association, the Area F trustees and officers of the State Bar, the meeting sponsors and other individuals whose help was instrumental in making the meeting a success. Do we have a motion to adopt proposed resolution number 2? Second? Any discussion? All those in favor? Any opposed? And that motion carries. We did have a motion at one point during the pandemic to thank the staff, and we had some votes against it online. I thought, it was a little harsh. So these are both unanimously adopted, and I don't have my agenda up here, but I think that brings us, okay, we'll do the Distinguished Service Awards at lunch. So leading into the lunch, we'll start our CLE at noon. Jason DeSanto from Northwestern Law School will be here. He's a compelling speaker. But we, starting around 11:30 in that section, then we're gonna have a buffet lunch, get your lunch, and we'll do our Distinguished Service Awards and recognize those folks leading into the CLE at noon. So if we shift over there across the hall, the law school update will take place, and then there'll be the introduction of the case by the law student, and then we will hear the case from the Montana Supreme Court. So thank you all for being here this morning.
behalf of Dean Elaine Gagliardi, who is so sorry that she couldn't join us this year. I am here to give the annual update from the law school, and with me today is Alex Rich, our Director of Development at the law school, and Emily Caton, our new Assistant Dean for Career Development. I'd like to start my update by highlighting some of Dean Gagliardi's successes. Under her leadership, the law school remains in the top 100 law schools in the country, according to the US News and World Report rankings. Emily is going to talk more about the law school's outcomes and successes our graduates have. But it's important to highlight that among our peer schools, and our peer schools in our neighboring states include Idaho, Gonzaga, South and North Dakota, Wyoming, Colorado, and Oregon, our metrics, as determined under ABA reporting standards, are quite high. We rank number 1 in 2-year bar passage rates, and number 1 in employment for our graduates who are 10 months out following graduation. We are in the top 20 nationwide for best value. We are in the top 10 nationwide for placement of our graduates in state court clerkships. And among our peer schools, we are top among our peer schools for placement of our graduates in federal court clerkships. How we achieve these successes is by staying true to our mission. Our mission is to prepare our students for the people-oriented practice of law by integrating theory and practice. We continue to lean into this mission even as the world around us and the technology we use changes. We've added generative AI courses to our curriculum. We integrate AI skills into all of our courses. We are very excited to announce that the law school that Mitch Werbel has joined the faculty as a tenure track member. Mitch will teach courses in property law. He is a member of the State Bar. Many of you may know him. Professor Lori Freeman, many of you may know Lori Freeman. She has also joined the faculty as our Director of Academic Success. Student success is the heart of what we do. Our students draft contracts, write briefs, compete in trial teams, negotiations, moot court. They learn by doing. With us today are 3 amazing students. John Moorhead, you could wave. John Moorhead is an editor on the Law Review. He co-authored the significant Montana cases for the Montana Law Review. He's going to return. He's a third-year student. He'll be returning to Northwest Wyoming, where he will embark on his legal career next year. Addie Slanger, also a third-year student, co-editor-in-chief of the Law Review, will clerk for Judge Johnstone on the Ninth Circuit Court of Appeals next year. And Julia Wynn from Big Fork, Montana, is a second-year law student. Julia will be introducing the case on behalf of the Montana Law Review this morning. I'm going to turn it over to Emily Caton, our new Assistant Dean of Career Development. Emily is a graduate of our law school. She's a member of the State Bar, and she clerked for Judges Thomas and Morris and practiced in civil litigation in Montana before joining us 4 short weeks ago at the law school.
Good morning. Thank you, Dean Browdy, for that introduction. As Dean Browdy said, my name is Emily Gutierrez Caton. I'm the Assistant Dean of Career Development. I am very new to this position, but so far my approach has been that about half of my work is to be with students, work on their professional development, their goals, polish their resumes and cover letters. But the other half is to work with you all and to get to know the employers and the judges and the lawyers in the state. And so I look forward to, over the coming years, getting to know you all. I'd love to hear your feedback if you have any ideas for what we need to do better or what we could improve on. please reach out. I'm really happy to hear from all of you, and I hope to travel around the state getting to meet more of you in the upcoming years. And one of the reasons I was drawn to this job was, well, I love the law school, but also the unique ability to work with both students and lawyers, which I just find really interesting. So I'm so excited to be here. I want to talk briefly about some employment statistics. As Dean Browdy mentioned, we continue to have high bar passage and employment rates. I can take credit for none of this, but I'm happy to report on it. Our 2-year bar passage rate is 97.5%. Our employment rate is 96%, and that's at that 10-month look back. This data is for our 2024 grads. We continue to have incredible clerkship placement. As Dean Browdy mentioned, we're in the top 10 in the nation for placing students in state clerkships. Out of the graduating employed class of 75, we placed 7 in federal clerkships and 11 in state and local clerkships. As far as salaries go, more recently, we've seen some firms, regional firms, moving in and offering our top candidates in the range of 150,000 and above. So that salary range is changing a little bit here with some bigger firms in our state. We had 2 students recently selected for JAG commissions, which are highly prestigious appointments as well. Around 80% of our graduates stay in the state. Over the last 2 years, we've had 22 lawyers come to Helena, 12 to Bozeman, and 11 to Great Falls, among many other counties around the state. But one of the things I'd love to work on is connecting with employers, lawyers, and judges in the eastern part of the state, so we can work on getting more lawyers in those areas and work on the access to justice issues that we've all talked about over the last day or so. This also is no thanks to me, but I'll give a brief admissions update on behalf of our dean, Mary Althauser, who many of you may know. She works really hard and has really transformed some of these metrics over the last couple of years too. The incoming class of 1Ls is 96 students. That's been consistent over the last few years in terms of size. The median LSAT score of the admitted students went up 2 points over the last couple of years, from 154 to 156. And the median GPA of our incoming 1Ls went from 3.48 to 3.64 over the last 2 years. So again, these numbers reflect the work and successes of the law students and also the lawyers in this state. So thank you so much. I look forward to working with you all.
Good morning, everyone. I've met a lot of you, but I'm Alex Rich, and I'm our Director of Development for the law school. So I have the fun job of doing all our fundraising and working with all you guys. I really appreciate the opportunity to share a brief update on our fundraising efforts and the impact that your support continues to make. Over the past 2 years, we've made meaningful strides in advancing our law school's mission through philanthropy. Thanks to the generosity of our alumni and friends, we have surpassed our annual fundraising goals, securing nearly $2.6 million in new commitments. These gifts have directly supported our student scholarships, faculty excellence, and experiential learning opportunities that prepare our students for practice-ready careers. Looking ahead, our top priority is expanding our access to legal education. And that means that we're focused on expanding our scholarship endowment, especially in light of federal loan changes in the country. We also remain focused on securing support for our invaluable faculty so that we continue to retain and recruit Montana's best. And we also focus on our experiential learning opportunities like our trial team, moot court teams, and our clinic programs. I also have a really exciting announcement, and I really wish Bob Carlson and Bob Phillips were here because they were integral in coming up with the idea to establish the State Bar Montana Past President's Law Scholarship, which we, over the last year, have successfully endowed through the support of many folks in this room right now. This effort has not only created a lasting legacy of support for law students, but it has also demonstrated the power of collective generosity within our legal community. And we really thank you for that. We're excited to provide this inaugural award this academic year and in perpetuity as well. We're incredibly proud of the progress we've made, and we know it wouldn't be possible without the support of our entire Montana legal community. So thank you all for standing with us as we continue to shape the future of legal education here in the state. And please come talk to me if you'd like to learn more about investing in Montana's law school. Thank you, guys.
Thank you so much, Alex and Emily. Before I wrap up, I want to mention some upcoming events at the law school that we would love for you to be a part of. Next week is the Public Lands Law Review Conference. The title of the conference is The Changing Landscape of the Administrative State. After that, we've got homecoming. The law school hosts a tailgate, weather permitting, outside or inside at the law school, October 11th. My personal favorite for the Better Section members in this room is the Montana Tax Institute, October 24th and 25th. Upcoming into the spring, you can look for Advanced Trial School, will be held in May or June of next year. We also plan to do a generative AI skills for practitioners CLE sometime in the spring of 2026. And the big ticket item is that the law school will host the Celtic CLE in Cork, Ireland, May 25th through 29th of next year. We invite you to join us on that CLE. It's estimated for 15 credits of CLE. Class will be held 9 to noon every day with court opportunities to observe court in session in Ireland, an event with local attorneys. The topic and theme this year is corruption and anti-corruption. The approaches for legal accountability for corruption in the United States, in Ireland, and in the European Union. The faculty who'll be teaching are Andrew King-Reese, Anna Conley, and Karen Van Essen. There's information on the law school website, and we've brought some materials that are outside on a table. So I hope you will join us for that exciting opportunity. And with that, I'm going to introduce the student who will be doing the introduction for the Supreme Court oral argument. So I'd like to introduce Julia Wynn. Ready? I'm going to close this. Is that okay? Julia Wynn, like I said, is a second-year law student from Big Fork, Montana. She serves on the Montana Law Review. She also works as a JP, a junior partner, as a teaching assistant for our legal writing program. You ready? Yeah. Okay. Thank you, everybody. Yeah, thanks.
Good morning and welcome, everyone. My name is Julia Wynn, and I am a second-year law student at the Alexander Blewett III School of Law. Thank you, Dean Browdy, for the introduction. On behalf of the Montana Law Review, I would like to thank the Montana State Bar and the Montana Supreme Court for allowing me to introduce this case. We are here today for the oral argument in the case of Wild Montana versus Gianforte. This case is about the process for legislative override of a gubernatorial veto under the Montana State Constitution. More broadly, it involves questions about justiciability. As an initial matter, however, the parties dispute whether the court has the power to hear the case. The appellees may argue this case is moot. The appellants may argue that the appellees did not have standing, or that in bringing this case, the appellees are raising a political question. The parties in this case are Wild Montana, Montana Wildlife Federation, and Montana Association of Counties. I refer to this group as the proponents of the legislation. The proponents sued Governor Gianforte and Secretary of State Jacobson. I will refer to them as the governor and secretary, respectively. I'm going to tell you the facts of the case. I'll then explain the legal issues before the court and preview what you're likely to hear from the parties today. According to the proponents of SB 442, if the bill had passed, the proponents would have benefited from an allocation of millions of dollars in tax revenue. On May 1st, 2023, SB 442 passed the legislature with support from more than 2/3 of the members of both chambers. The bill was then sent to the governor on May 2nd. That afternoon, the governor vetoed SB 442. The governor then returned the vetoed bill with an accompanying message to the legislature that same afternoon. At approximately 3:20 p.m. that day, the Senate passed a sine die motion and subsequently adjourned. Sine die means to adjourn without setting a date to reconvene. The vetoed bill was not read across the rostrum in the Senate. The vetoed bill remained in the Senate's offices and was not returned to the governor. Though the Senate had adjourned, the House of Representatives continued working through the evening. The House read the governor's veto message across the rostrum. The House adjourned without holding a vote. With the Senate also having adjourned, the 68th legislative session officially concluded. The process for legislative override of the veto is set forth in the Montana State Constitution. Under the Constitution, the process depends on whether the legislature is in session at the time of the governor's veto. If the legislature is in session, the governor must return the vetoed bill to the legislature with his reasons for the veto. If the legislature is, quote, not in session, the vetoed bill has been passed by 2/3 of the members of both chambers, the governor follows a different procedure. In such a case, the governor must give the vetoed bill to the Secretary of State. The Secretary of State then must poll the members of the legislature by mail, giving them the opportunity to override the veto. In response to the governor's veto and the unexpected adjourning of the Senate, the proponents of SB 442 urged the governor and secretary to conduct a veto override poll. The secretary did not poll the legislature. The proponents of SB 442 filed suit in Lewis and Clark County. The proponents sought declaratory relief and a writ of mandamus to require the secretary to conduct a veto override poll by mail. The district court granted the proponents' requested writ of mandamus, ordering the governor to send his veto message to the secretary, who was in turn ordered to conduct a veto override poll of the legislature. The district court found that the governor vetoed SB 442 before the legislature had adjourned. However, the court reasoned that the combination of the timing of the governor's veto and the Senate's unexpected adjournment created a, quote, procedural gap in the veto process. The district court reasoned that the Constitution does not grant the process for when the governor vetoes a bill while the legislature is in session, but the legislature does not receive timely notice of the veto prior to adjournment. The governor and secretary asked the district court and the Supreme Court for a stay of the proceedings. Both courts denied the stay. In denying the stay, the Montana Supreme Court said that the governor's appeal would not be made moot by the denial of the stay, quote, because the fate of SB 442 could ultimately go either way. After the Montana Supreme Court denied the stay, the secretary complied with the district court's writ of mandamus. She polled the legislature. In response to the polling, the 2023 legislature did not vote to override the governor's veto. SB 442 did not become law. The governor and secretary appealed the district court's decision and writ of mandamus. And that brings us to the legal issues on appeal today. There are essentially 4 issues on appeal. The first 3 issues are about the court's ability to hear the case. They are mootness, standing, and whether the political question doctrine prevents judicial involvement. The fourth and final issue is the question about the process for legislative override of a veto under the Montana Constitution, in particular, when these unique timing issues arise. First, the court may address the issue of mootness. The parties disagree about whether these events are likely to reoccur. If they are not, the issue in this case is moot. The proponents may argue that because the override veto poll had been conducted, no effective relief remains available to the governor. Thus, the governor's appeal would be rendered moot. On the other hand, the governor may argue that the public interest exception to mootness applies. Under Montana law, the public interest exception applies when the issue being disputed is one of public importance, is likely to reoccur, or is one to which an answer would provide guidance to public officials. The proponents, however, may dispute whether the issues on appeal are likely to reoccur. In the discussion of mootness, you may also hear the parties refer to another piece of legislation, SB 344, which was passed in the 2025 Montana legislative session. SB 344 clarified what would constitute effective delivery of a vetoed bill by the governor. Alternatively, the governor may argue that if the case is moot, the proper course is to vacate rather than reverse. Vacature is a mechanism the United States Supreme Court sometimes uses to void legally erroneous lower court decisions that are otherwise moot. Here, vacature by the court would essentially erase the district court's decision. The second legal issue is the question of standing. The governor and secretary may argue the proponents of the legislation, as private plaintiffs, lacked the appropriate standing to bring their claims against the governor and secretary. The governor and secretary may also add that any alleged injury was caused not by the governor and secretary's conduct, but by the legislature's decision to adjourn prior to voting on the governor's veto. Conversely, the proponents of the legislation may argue their interests and resulting harm were distinct from the general public because they were meant to be the beneficiaries of SB 442. The proponents of the legislation may argue that the governor and secretary are the proper parties because their refusal to conduct an override poll violated the proponent's right to fair government process. The third issue involves the political question doctrine. The political question doctrine is about whether the district court had authority to hear the case in the first instance, or whether the doctrine bars judicial intervention. Under Montana law, the political question doctrine prohibits courts from reviewing policy choices and issues reserved exclusively for the legislative branch, the executive branch, or the public vote. The governor may argue that the district court didn't have the power to hear the case because of the political question doctrine. The governor may argue the district court interfered with the legislature's power by issuing the writ of mandamus. The governor may argue the Constitution's language grants the legislature the exclusive authority and tools to fill any such procedural gap within the veto power provision. Conversely, the proponents of the legislation may argue that it is not a political question for the court to interpret the language of the Montana Constitution. The fourth issue concerns the substantive question about the veto override process under these factual circumstances. In issuing the mandamus, the district court essentially ordered a veto override poll, even though it found that the legislature technically was in session at the time of the veto. The district court justified this order based on the, quote, procedural gap. The governor may argue the provision's text suggests that the governor's duties upon vetoing a bill depends on the status of the legislature at the time of the governor's veto. The governor may argue that he followed the appropriate procedure when he sent the bill to the legislature because the legislature had not yet adjourned at the time he vetoed SB 442. The secretary may then argue that because the governor sent SB 442 to the legislature, she never received the actual bill and thus could not have had a clear duty to poll the legislature by mail. The proponents may argue that the intent of the Constitution's veto power provision is to give the legislature the final say on the passing of a bill. The proponents may also argue that even though the Senate was in session at the time of the governor's vetoed SB 442, the Senate lacked the notice necessary to act on the veto prior to adjourning. Because of this, the proponents of the legislation may explain that an override veto poll was appropriate to enforce the intent of the Constitution. This case is somewhat unique in that there are multiple parties in opposition. In this oral argument, you will first hear from Dale Schoengert, who is representing Governor Gianforte. Then you will hear from Austin James, representing Secretary Jacobson. Finally, you will hear from Riley Summers Flanagan and Mike Black, representing the proponents of SB 442, Wild Montana, Montana Wildlife Federation, and Montana Association of Counties. Again, I would like to thank the Montana State Bar and the Montana Supreme Court for allowing me to introduce this case to you all today. I look forward to hearing the arguments.
Morning, everybody. Am I muted or am I good? Oh, good morning, everybody. This is the time set for oral argument in DA 24-0153, Wild Montana, Montana Wildlife Federation, and Montana Association of Counties versus Governor Greg Gianforte and Secretary of State Christy Jacobson. As a large venue, I'm going to take a moment to introduce all the members of the court. So Justice Shea is appearing remotely by Zoom. Justice Shea, can you see and hear us? Like, I'm going to introduce everybody else. You guys give me a thumbs up, please, when you get him online. Oh, that's me. That's not Justice Shea. He has a much more distinguished looking hairdo than I do. Justice Gustafson could not be with us today, but she is participating in the panel, so she'll watch the recording. To my right is Justice Catherine Bittigary. And my immediate right is Justice Beth Baker. I'm Corey Swanson. My left is Justice Lori McKinnon, and then Justice Jim Rice. So we're dividing time, council. Is that worked out? Okay, so appellants, how do you want to divide time? Appellees? Are you saving rebuttal time?
Do we have Shay?
Oh yeah, let's see if we have Justice Shea. Justice Shea, can you hear us and see us?
I can hear and see you.
There you go.
Can you?
In Boom Butte.
Good, counsel?
Mr. Chief Justice, and may it please the court, Dale Schongert for Governor Greg Gianforte. With me today is Secretary of State's Chief Legal Counsel Austin James. As we mentioned, we'll be splitting argument. This case is about who sets the procedural rules for vetoes in Montana. Article 6, Section 10 lays the framework. There are two lanes. If a bill is vetoed while the legislature is in session, it's returned to the governor. Returned to the legislature. If it's vetoed while the legislature is out of session, it's sent to the Secretary of State. There is no third lane for a court to write in rules near adjournment. Here, the governor vetoed SB 442 while the legislature was in session and followed the only procedure that the Constitution provides. And that's a point that the legislature itself confirmed. The district court's order should be reversed for three reasons. First, by creating a new veto procedure, the district court's order usurped authority reserved to the legislature. Second, private interest groups lack standing to litigate on behalf of the legislature, especially when the legislature views their suit as a trespass. And third, this case is not moot because the governor sought a stay. After that stay was denied, complied with the writ, and the public interest and capable of repetition exceptions to mootness apply. In the end, the Constitution provides two lanes for vetoes, not three, and the governor followed the in-session procedure the text commands. I'd like to start with the separation of powers and the political question doctrine. The inquiry is whether the Constitution commits a question to the political branches and whether there's a judicially manageable standard to resolve the issue. Here, both of those inquiries go to the governor's favor. And the political question doctrine is based on the separation of powers. And when the court is dealing with procedures of a coordinate branch, it has a special force. And this court dealt with that in Coate v. Olmholt when the legislature tried to interfere with the court's procedures and set a timeline for when the court had to issue opinions. The court said and analogized to the court interfering with the legislature's procedures. The internal operating procedures of a branch is a political question. That is an issue for the branch to address and resolve.
Mr. Schongert. how the district court characterized Article 6 as having a procedural gap. Maybe he was wrong with that.
Yeah. I think he was wrong with that to a certain extent. I think the gap is that the framers, and you see this in the debates at the CONCON, the framers left the procedures, the timing, how the legislature receives a veto, processes a veto, and informs its members, left that to the legislature. So is that a gap? I think if it's a gap, it's a purposeful one. That's for the legislature to handle, and it can handle that. It's got lots of tools to handle that. It can do it through joint rule. It can do it through statute. It's in other contexts, it's done both.
And that relates to the question I was going to ask as well. Just to elaborate a little on an argument you make in your briefs, which in the political question portion of that, you say that it's a political question because this is not a self-executing provision. Instead, it's left to the legislature. It is different. I want you to elaborate a little on why it is not self-executing, because does the provision require legislation to execute it, or does it only require something because of this procedural gap that the district court found? Could you just elaborate on why this section of the Constitution is not self-executing?
Sure. It's not self-executing because any action is directed for the legislature to take, or the executive to take.
It doesn't really direct any action in order to implement. I mean, it just sets out the process.
I think that's fair. I think that's fair. But the difference here is, and I don't see political questions being cabined to only when it says the legislature shall provide. I think the question is, does this leave it as a practical matter? Is this left to the legislature? And I think when we're dealing with procedural rules of a branch of government, that is almost the most, the most basic issue that's left to that body, just like it was left to this body. So, and I think that's the issue. Now, there could arise disputes between the legislature and the governor or other public officials that this court resolves. But when it's determining how a veto is processed, how members are informed, that's the legislature's business. And especially in a mandamus case where the governor, he did exactly what he was supposed to do under the Constitution. And in fact, I don't know what else he was supposed to do. Vetoed the bill, sent it to the legislature. And so the complaint from my friends on the other side of the case, and then there was a couple declarations in the record, was that it wasn't read over the rostrum. There wasn't an opportunity to read the veto on the rostrum. Again, that's the legislature's business. How it accomplishes that is up to the legislature. One practical point here: the court, it's common before a motion to adjourn sine die to ask if there were veto messages from the governor, or ask if there are any messages from the governor. That wasn't done before this adjournment sine die. It wasn't done. The motion was made at 3:18. The last request for messages from the governor came in at 1:48. And so Senator Flowers didn't ask. He could have. It's fairly traditional to do that. That's up to him. That's up to the legislature. If he had, presumably they would have discovered there was a veto, and they could have decided whether to deal with it or they could have read it over the rostrum at that point. But that's nothing that the governor or the secretary of state have control over.
In terms of the political question argument you make, it seems to be nuanced because you acknowledge in your briefing that the courts have the power here to ensure that legislation was handled consistent with the text of the Constitution. So to that extent, it's not an improper political question, correct?
It wouldn't be if there were a dispute over what, let's say a different factual, we had a different factual circumstance. Let's say the legislature said, we got your veto, but it wasn't in time. And they sent the bill back to the governor. There's a factual dispute there about whether the legislature received it before adjourning signing die. The court could, I think, resolve that. The court could resolve what the Constitution means, what the Constitution requires. Does it require receipt of the veto before adjournment? Those aren't at issue here. The legislature retained the bill. The legislature confirmed that they received the veto while they were in session. And so there was nothing left for the governor to do. And that's when we're dealing with the procedures of how the legislature receives a bill, how it informs its members, whether it reads it across the rostrum and when. Those are all procedures. Those are all left to the legislature. It's not for the governor to decide. It's not for the court to decide. But that's the issue we have here. And that's what I think sets this apart from a normal case that would, obviously this court has power to interpret a statute, apply the statute, same with the Constitution. But
so the district court violated the political question doctrine when it went so far as to say, well, we got this language about reading over the rostrum, and that's really the key thing here. And so that took this case too far?
That is what took this case too far in part. I mean, you read through the district court's order, and the only facts in this case that were introduced was that members weren't aware, that some members at least weren't aware of the veto. And that is what took the case too far. I mean, like I said, we would be in a very different position if the legislature had sent the bill back and said, we didn't get it. We didn't get it in time. Have the bill back. But that raises another point. The district court called the possession of the bill form over function. It's critical. Just as the legislature can't act, I mean, before the governor sends the veto bill back, they can't preemptively override the veto. The governor can't act if he doesn't have the bill, if it's not returned by the legislature, nor can the Secretary of State. And I think that's another error that the district court made here.
Council, and you've raised a lot of issues of the standing, the political questions doctrine, the mootness. How are we to navigate going forward this case? And if we find there's no standing, we don't get to the political questions doctrine. Right? I mean, which way do you want us to go?
That's a great question. Should I have all of it?
No, I think they're kind of inconsistent.
No, it's fair. Very fair question. I think the most basic way to resolve this case is standing. And this is the issue I was going to get to next, because it's closely related to the separation of powers here. I think it's pretty dangerous precedent to allow private parties to sue on behalf of the legislature when their own individual rights are not at issue.
Then we don't get the question answered about staying in the right lane of travel.
That's true, but I think it also makes it less likely that these issues will recur. Because I mean, look, the district court's order makes this much more likely to recur if private parties can sue on behalf of the legislature for any procedural, perceived procedural violation.
So do we go to standing or we go to mootness first?
I think you could go to mootness first. I mean, I think mootness. I think you probably have to resolve mootness first, and I think to determine standing. I can't figure a way around that.
I think of standing as standing at the beginning of the case.
Yeah.
Mootness at any other point in the case, it was due to subsequent.
I think that's right. Okay. And so I think in order to satisfy the court that it has the power to resolve the case, I think you have to address mootness first. And the case is not moot because, look, the court said it wasn't going to be moot, and it wasn't going out on a limb and saying that. I think the public interest exception applies. That the case presents an issue of public importance. This court has said that the coordinate duties of public officials and the separation of powers is inherently an issue of public importance.
So let me ask you a question about that in light of. And I tend to agree that in itself, that bill doesn't render the case moot by addressing the exact same issue. But does it affect a future case involving these exact same facts or very similar facts in terms of whether these exceptions should apply, because wouldn't we have to wade into how the amendments, the 2025 amendments affect this whole issue?
I think the easiest way to determine how it affects the issue is by its terms, it's limited to adjournment for the day, but not for the session. And, the petitioners in this case have said all along that, hey, both houses have to be informed of the bill and be able to act on it before adjournment sine die. That bill, if the plaintiffs are right, that applies to to adjournment sine die, only one house needs to have the veto. The other one could have already adjourned. If the legislature was going to do that, I think they would have said this applies to adjournment sine die. They didn't.
Well, and I'm following up on Justice Baker's question. I mean, the legislature through Senate Bill 344 did exactly what you're saying they should be able to do.
Yes.
Which is answer that question about legislative override. How do we, and that's why you're saying this is not moot as well. So how do we, it's implicated 344, yet it hasn't been heard in the district court. It hasn't been challenged, and we would have to address whether the scenario you have presented, that it really doesn't identify the process after the legislature sine dies in this case without it. So
I follow. So I think the way to deal with that issue is pretty straightforward. I mean, the district court made a constitutional decision. It interpreted the meaning of Article 6, Section 10. That trumps the statute. And so if the district court was right, and there is no way to reconcile what the district court said was required in SB 344. So this court can assume, you can assume that it applies. I don't think it does, but even assuming it applies, it's still at odds with the district court's decision. And I think this is an issue that needs resolution by this court. Unless there are further questions, I'll turn it over to
Justice
my
Shea.
colleague.
No, good.
Good morning. May it please the court. Austin James on behalf of the Secretary of State's office. District Court ruled by mandamus that the Secretary of State has an undoubtedly precise obligation prescribed by the Constitution that is independent of the governor's office to decipher whether the members of the legislature are aware of the governor's return physically before the first house moves to adjourn sine die. That purported obligation is not found anywhere in the Constitution, anywhere in statute, and only in the text of a mandamus order itself. The Secretary of State has been historically, and should continue to be, a ministerial office in the post-session process. A dusty procedure guided by statute in Montana Code Annotated 54306 has been performed by less than a handful of public servants in the last 4 decades, is simply based on conditions that exist for the Secretary of State to do their job. Secretary of State receives a bill from the governor. They receive the bill after the session. The bill is then copied. The bill is accompanied by the veto message. The Secretary of State makes polling ballots, and the Secretary of State has 5 days to get it out. Putting the Secretary of State in a position where the employees are not, no longer is it a public servant's ministerial process, but instead where the Secretary of State is given an independent obligation born in the Constitution to then be able to decide whether the members of the legislature are aware, puts the Secretary of State as part of this political process, and that is bad for the Constitution and for our governance.
So counsel, I guess you're indicating 2 things the secretary would have to do on her own. 1, determine if the governor's vetoed the bill. second, determine whether the legislature received the veto before it was out of session. Is that correct?
Chief Justice, that is correct. And those conditions are not found in the Constitution. And that brings me to my first point, that under our standard for a writ of mandamus, both of our prongs have not been met and should not have been issued below. First, we know that there must be a clear legal duty and that there's no adequate and speedy remedy in the ordinary course of law. That clear legal duty has been established by this court as something that is so precise and can be performed with such precision and certainty as to leave nothing to judgment. Judgment like the Secretary of State judging whether the members of the legislature are aware when they move or vote on a sine die bill. The record below shows that the bill was returned during the session. The member who moved for sine die, as the Secretary notes in her supplemental brief on page 2, acknowledges that the bill was delivered to the body during the session, but that they were not aware. The Northey Declaration below also indicates that the bill was returned to the legislature in session, and then it was handed over to the legislature. The plain meaning of the Constitution's mean returned, delivered to the legislator. Thus, the record only establishes that the bill was delivered when the session was still ongoing, and there is no duty whatsoever for the Secretary of State when the legislature is in session. The court could not find a clear legal duty, and instead, in finding a clear legal duty that does not exist, put something that lacks the precision that the very test of a writ of mandamus requires. This is problematic, and all that is enough to return to the district court and overrule the mandamus. The Secretary of State has no duty on a bill vetoed during the session, no duty on a bill that she has not received, and no duty until the time has lapsed, even under statute. And that brings us to the second prong. And as Justice McKinnon noted in the majority of the MAIC decision just recently, it's very important that the district courts pay attention to the second part of the mandamus standard and scrutinize whether or not there is actually no adequate and speedy remedy in the ordinary course of law. The decision that is before you today analyzes the prong as to whether there is any adequate, speedy remedy in the ordinary course of law with 3 words. The order provides, there is not. That is not the type of analysis that we have established is required by district courts to evaluate. And the fact is, there is adequate and speedy remedy, both in the political course of law and in the legal course of law. First, these are lobbying groups. Montana Code Annotated 53105 says that 10 members of the legislators can sign on to a letter to the Secretary of State to poll for a special session. It is easy for a lobbying group to be in contact with 10 members of the legislature, especially if they're popular legislation, to convene a special session and to consider the bill. Second, the Constitution provides that the legislature has a right to override any bill vetoed by the governor, even those that receive less than 2/3 vote, by 54306(3). So let's say that the district court was right and the legislature was indeed out of session, and let's concede that a return requires announcing it over the rostrum and set aside the points that Mr. Schoeninger made that it could have been asked as to whether it was returned. Even if the Secretary of State had a duty because it had been returned after the session, there still would be an ability for the legislature to override the veto pursuant to the Constitution, because there's an ordinary course of law remedy that is borne by the legislature being able to have a special session. Now, the district court didn't weigh the adequacy, which is part of that prong. I do not know why, but clearly the legislature believes that the special session process is an adequate remedy because the legislature adopted that process in statute in addition to where it is found in the Constitution and hasn't changed it. So we do have an ability to reconsider under the law. And finally, and I think this is a tremendous point, this is not a scenario where the district court ruled by a summary judgment on declaratory relief and then entered that judgment, and then that the Secretary of State failed to do what the court had ordered her to do. It is instead a situation where the court entered judgment only on the writ of mandamus, and in the writ of mandamus declared what the law is. That is not the purpose for a writ of mandamus, and there is an adequate remedy under the legal course of operation because the party could have received declaratory relief and then pursued a writ of mandamus if the Secretary of State refused. You can't ask a public officer to do something that is nowhere found in law by a petition or a letter and then file a writ of mandamus and say, my theory deserves to be mandated. It is not within the writ of mandamus doctrine. So under either prong, the Secretary of State asks that you acknowledge that under our doctrine in Montana, the writ of mandamus should not have been issued and that the writ of mandamus should be reversed.
Mr. James. Go ahead. Well, I was just going to ask you to address Justice McKinnon's question put to the Governor's Council about what comes first for us in deciding this case. Your argument focuses on the merits of the mandamus. What do you think about whether we should get to that question?
Justice Baker, there is no doubt that the Secretary of State remains fearful that lobbying groups can file an action and have standing against the Secretary of State for legislative procedural rules. Standing is a tremendous concern. Most importantly, we believe that both on standing and mootness grounds, we persevere. But nonetheless, we still acknowledge that the writ of mandamus itself needs to be overruled because the Secretary of State remains in this position where, regardless of what is said in statute, we have to obey the district court's constitutional interpretation. And the record also establishes that there are other bills that are in the same scenario, right? I believe there have been 4 instances in the last 15 years where the bills have been returned. And if the lower court's constitutional ruling remains, then that means that other interest groups who support those bills can go to district court and ask for the Secretary of State to pull on those bills, putting the Secretary of State in harm.
So counsel, if I understand what you're saying, there was no clear duty under either provision of the legislative override, but you want an answer for the Secretary of State going forward. So that puts us, I mean, you're not quite with the governor in terms of position, I don't think, because the governor's position is that there's this area, a procedural gap identified by the district court where the legislature has the exclusive authority to legislate in that area. They haven't done that. So the Secretary of State's problem has not been answered. But you are asking us for an answer, I guess, just on the limited issue of the mandate?
Justice McKinnon, we do agree with the governor's position, but what we'd say is if you don't like their argument, we have another. And we are dividing time.
They're not really providing an answer for what happened here. They're saying the legislature has to develop that answer.
I think that is correct too. And I believe that that's really why that mootness exception exists, because we are put in a position where this is obviously of tremendous public importance. There is this likelihood to reoccur because there are other bills that are put in the same position as this one that still that the legislature did not know about. We know that as a matter of record, and that if that ruling were to be consistent, it would apply. And so we would like guidance for the court, because even in implementing the writ of mandamus, we sort of had to make it up, right? Statute doesn't provide what to contain in that packet with when we don't have a bill. We don't have any of the scenarios that are clearly ministerially set out for us. And so, yes, I think that that's the second point, is that this is a huge deal to the office, and we are now put in a position where we need the classic form of American judicial relief. We need to be put in the place that we were before the harm created by the lower court's decision. And we'd ask you to reverse because of that ground as well.
So you're saying even if we disagree with the governor entirely on all their arguments, the secretary still did not have a clear duty to go find that bill or a copy of the bill and initiate the poll. Is that what you're saying?
I think that is correct.
So what do you think about their argument that we're treating this like it's 1910 and there's only one copy of the bill and you have to go get that copy, as opposed to the electronic world we live in where secretary can just get the bill and the veto message. In fact, probably already got it because you were CC'd. So their argument is you had the bill, you had the veto message. Why can't you execute that?
Chief Justice, I believe that ignores the fundamental process of the legislative lawmaking and the process of a bill. There is good reason as to why when a House committee votes on a bill and passes it, the House floor cannot simply go online and print out a bill and vote on it. Simultaneously, when the Secretary of State makes a bill law, for instance, let's say if the poll were to succeed, we would not have been able to assign a chapter number to the bill unless we have the physical bill. And that too would lead to constitutional frustrations. Perhaps the governor is delivering a bill that he signed to the front desk at the same time as an officer that is working on the veto override process is working to fabricate a bill. Which one comes first, and how do we assign the chapter numbers for its legal effect? The physical bill has tremendous significance, and we believe that the opposing party and the court downplayed that tremendous significance.
So just one more question about how your arguments do or don't dovetail with the governor's. One of the arguments the governor makes in the supplemental brief is that if the court should decide that the case is moot, it should apply the U.S. Supreme Court's Munsingware doctrine and vacate the lower court's judgment. Would that solve your concerns?
Justice Baker, it would not solve our concerns, but it would alleviate them. We believe that that's the least the court could do.
Okay.
If there are no further questions, I'd like to reserve the remainder of time for our rebuttal. Thank you.
Counsel?
May it please the court, Riley Summers Flanagan for appellees, Wild Montana and the Montana Wildlife Federation. My colleague, Mr. Black, represents the Montana Association of Counties. And of course, we have, as we've discussed already with the court, we are splitting our time, but we want to be clear that we fully embrace and endorse the arguments that are being made by both members of the team, so to speak. I'm really grateful to have an opportunity to argue this case in front of you all today, and I wanted to say thank you for inviting us to argue this case. Mr. Chief Justice and honorable members of the Montana Supreme Court, despite now being moot, the core of this case is at the zenith of judicial power. It is a case that is about constitutional interpretation, very straightforwardly. The Montana Constitution authorizes the legislature to override a governor's veto and carefully sets out a procedure that ensures the ease of that process when our citizen legislature has adjourned sine die at the end of the session. Much of the governor's argument focuses, when we get to the merits, on isolating Article 6, Section 10.4 and reading it very closely without consideration for its context, without considerations for its purpose. This court regularly, in cases like Nelson, Brown v. Gianforte, and several others, has repeatedly pointed out the importance of looking to the overall purpose and context of a constitutional provision. It does not stand alone, and it does not stand without the information that we have related to the purpose that motivated it. The Secretary, meanwhile, largely relies on the statutory framework and argues essentially that the constitutional text has no power or authority over her. That obviously can't be the case. And although this case does present a question that's now moot, if for no other reason than because of Senate Bill 344, and I'm excited to talk about that, the district court correctly decided the case and required the secretary and the governor to act in a manner that is consistent with Article 6, Section 10.4, which is a self-executing provision of the Montana Constitution.
It's very specific.
It is.
I mean, it's black and white. Yes. The Constitution, and I guess we're on the merits at the moment.
Yes.
The Constitution sets forth the veto scenario for either when the legislature is in session or it's out of session. That's the two options. And very clearly states that the polling option only arises when the legislature is not in session, when the governor vetoes a bill. That didn't happen here. And how can the district court legitimately order polling when this very specific, I realize we read in context, but this provision sets very specific parameters. Not all bills vetoed after the session get polling. I mean, it's very specific in context. So how can the district court legitimately say, well, this situation created an anomaly that we need to add something to the Constitution?
Your Honor, I would respectfully disagree that there's any addition to the Constitution here. And so what I want to do is turn us to the text for a moment, because I agree with you that it's quite straightforward. Of course, the interesting thing, right, is that when it's quite straightforward, we can still find ways to disagree. However, I would say there are actually three scenarios that Article 6, Section 10 addresses. The first is when the legislature is in session. When the legislature is in session, and of course, the legislature determines its own procedures for overriding a bill when it's in session. That is Article 6, Section 10(3). If after receipt of a veto message, 2/3 of the members of each house present approve the bill, it shall become law. They decide how to implement that portion of Article 6, Section 10(4). Second, we have 4A, and third, we have 4B. In 4A, we are talking about supermajority bills that are vetoed after the legislature has adjourned sine die, and we have vetoes of bills that are not supermajority bills. Those require calling a special session in order to override them. The idea that motivated Article 10, Section 4A, Section 10(4A, is specifically the idea that the people of Montana did not want the governor to have undue political power at the end of the session to prevent the legislature from being allowed to override vetoes. And that's exceptionally clear. And to the extent that there is a misalignment between Section 4A and Section 3 in how they are written, that misalignment we can quickly dispense with by looking to the intent that was expressed in the proponent language that was sent out in 1982 when Montanans voted on this bill. And voted on this amendment to the Montana Constitution. And so while I appreciate that there is language in here that says if the legislature is not in session when the governor vetoes a bill, if we focus exclusively on that and look at nothing else at all, we are doing a disservice to the Montana Constitution, which clearly intended to occupy the field when this provision was passed and added to this veto portion of the Montana Constitution. And so I appreciate that there may be a little misalignment between the sections, but I do not think that it actually gives rise to any distinction in the ways in which the governor or the secretary of state is intended to act. Now, the legislature can make, yes, please.
Go briefly. So your answer just helped me understand something I hadn't understood. On 4B, the legislature may reconvene as provided by law to reconsider any bill. So we're talking, we'll come back to this. So the scenario could be they do a veto override and they don't get 2/3 of each house. But they vote to reconvene special session and pass a bill again with simple majority. And maybe the governor vetoes it, maybe not. Like that's a scenario that 4B contemplates.
I think that could be a scenario that 4B contemplates. I think that 4B also contemplates the idea that if the legislature say they pass something by a margin of votes that does not reach the 100 votes that would be required to be a supermajority, and the legislature vetoes the bill, and perhaps, let's try a little hypothetical, the governor says in his veto letter something that irks a great number of the legislators, and they find that they have changed their opinion, right? It's never happened before, but maybe it could. Yeah. And so if that were to happen, the legislature could say, we actually changed our minds and we'd like to call a special session and override that veto. Okay. We stand by our legislative colleagues who voted for it in the first place.
Okay, so that's what I understand. Why 4B why couldn't the district court judge say, sorry guys, number one, you're not a bunch of legislators, but I don't see it in the plain text. Tell the legislature to call a special session. Why couldn't the district judge just do that?
Well, because our Constitution very expressly reserves a special procedure for the circumstances in which the legislature has passed a supermajority bill. That's the key here. The problem with this case and with the governor's conduct in this case is the fact that the legislature passed this bill by 130 votes, and that there's a lot of concern in the in the governor's briefing about the speed at which sine die occurred. There was also a great deal of speed associated with the speed with which the bill was vetoed in a fairly unusual manner. These are not things that should change the nature of the constitutional provision, which reserves to the legislature the absolute right to override a veto. Yes.
What should the governor have done differently? I mean, the Constitution doesn't give him any time on how soon he can veto a bill. So he didn't do anything illegal in vetoing the bill when he did he?
No, certainly not.
What should he have done differently here?
Well, Your Honor, when it became clear that the Senate had adjourned sine die, that is when you go and you say, we're going to take the bill and send it to the Secretary of State's office. You simply clarify, we didn't manage to deliver it in time. We don't have effectual delivery. There was no notice to the Senate before they adjourned sine die that this bill had been vetoed. And that notice is key. The question is receipt of the legislature. That's what we see in subsection 3. And that's where I think there's the misalignment of language. And that's also the definition that we're looking at. This is why we're in that, that firm ground for the judiciary, because what we're doing is defining the difference between out of session and in session.
So once he realized that the Senate had adjourned after he had done his job and sent it back, it was his responsibility to claw it back and resend it?
Well, Your Honor, I don't know that I think it's actually all that necessary that he claw it back. I think he could have made a phone call. And I am also not sure that the record actually shows that the delivery occurred before sine die occurred. And I don't want to try to raise a factual issue that is, but it isn't clear in the record. And the declaration it is now escaping my mind, but the name of the individual, I have it right here. Thank you. My colleague reminded me. The Northey Declaration does not indicate a time. It's in paragraph 8 of the Northey Declaration. And he describes delivering the veto. He is not able to say when he did that or to whom. I don't want to interrupt anyone's train of thought, but I may turn us to mootness for a moment. Mootness is a threshold justiciability question. And the key with mootness is that we absolutely do address it first. So we should address mootness first. That's what the court should turn to first. This case is moot because the court cannot grant relief.
Counsel, and I don't think you addressed this in the reply brief, but we have a DEC action, a judgment. And what about review of that? I mean, doesn't the fact that the action has been decided by the court in terms of rendering a judgment, doesn't that provide appeal?
No, Your Honor, not in this circumstance. And I have 2 reasons why that's true. First, I want to turn, Your Honor, to the decision in Broad Reach Power versus PSC. This is a 2022 case. 2022, you all are, I'm sure, familiar, but I will say the citation, 2022 MT 227 in paragraph 10. The courts have no jurisdiction to determine matters that are purely speculative. And I'm skipping to the bottom of paragraph 10. The Uniform Declaratory Judgment Act does not license litigants to fish in judicial ponds for legal advice. That is exactly what will happen here. And I want to turn us to 344 in order to understand why that would be the case, because I will say that I think with absent SB 344, the court may have a more difficult decision on mootness, but with the passage of 344, which the governor signed and agreed should go into law, we see that there is really no way that this set of facts can recur. And so the Uniform Declaratory Judgment Act does not give litigants an opportunity to manufacture a controversy that does not exist any longer and that no longer concretely impacts anyone.
I'm not. It seems to be the same thing happened again. I Am I missing that?
I do think that the governor's interpretation of this is correct, except that he does not reach the obvious conclusion, and that may be where we differ, Your Honor. Now, I want to take us directly to the text of 344. This gets incorporated into the code at 54306. Return when the legislature is not in session. Now, what happens here is return when the legislature is not in session. The first subsection 1, refers to when a house has adjourned for the day, not for sine die. The second subsection 2, refers to when the legislature is not in session, and specifically when either of the chambers has adjourned sine die. And that is exactly what's happening here. So if we go through the governor's supplemental brief, he on page 8 of the supplemental brief writes, moreover, while 1A explicitly says that it applies to vetoes issued when the originating house has adjourned temporarily, 1B does not say that it applies to vetoes issued after one house has adjourned sine die. Of course it doesn't, because you can't effectually deliver a veto when either chamber has adjourned sine die.
Subsection 2 is existing.
Subsection 2 is existing law, absolutely, and it covers that scenario. What the amendment to subsection 1 and the addition of B does is it clarifies how do you get effective delivery when the legislature is in session.
How can we get into all of this?
I agree, Your Honor. You can't. And the reason that you can't is because, and this, I want to take us to a case. It is true that sometimes a change in the law allows you to reconsider a case. Some of the cases that arise in this context are cases where we're talking about the issuance of licenses, and the law that governs the issuance of licenses changes in the midst of the appeal. The appellate court applies the new law about the issuance of licenses, right? It doesn't change the fundamental nature of the controversy. But when a change in the law would cause the appellate court, and I'm going to quote here, to reframe an appeal to review what would be in effect a different case than the one decided by the district court, you don't go there.
But how does this make this a different case if it didn't change the subsection of the statute that applies to this case?
Your Honor, I think that what it does is it changes the nature of the receipt of the veto and the veto message. And it clarifies that that must be done because, and I would actually argue, Your Honor, that what happened here is that there was confusion about when the Senate received the veto message and the veto of the bill. So the issue that arose under 1A, and you'll notice that what it says in section 1A that was deleted is that that anyone could receive the veto message. It says that delivery is effectual as though returned in open session if the governor on the first day, again, by message notifies it, who is it, of the delivery and of the time and when and the person to whom the delivery was made. There's no opportunity for that to occur in this circumstance. We didn't spend much time in the statutory language. Neither side raised it before. But when we look at this change in the law, it fundamentally alters the nature of delivery, and it clarifies. And I would say there's a chance. I don't want to hide the ball, and I don't want to overstate my case here. I think there's a chance that unconstitutional conduct could still occur, even in compliance with this bill. I think we have to work very hard to find the hypothetical in which that happens. I think that had Governor Gianforte complied with this, with SB 344 as written, that we would not be here today. And I think fundamentally that's what mootness is. The question is, does this bill change the nature of the facts of this case to such a degree that it cannot recur? Because what are we looking at when we're talking about mootness? First, we're asking, is there a controversy? And second, we're asking, if there is no controversy, does one of the exceptions apply? One of them is the public importance exception. Another is capable of repetition, but evading review. In both of these exceptions, it is necessary that the person asking, that the party asking for a mootness exception show that this is capable of recurrence.
So let me, before you run out of your allotted time.
Yes, I am so close.
Let me ask you about a question that you haven't had a chance to address because it was in the governor's supplemental brief, that if the court does agree with your argument that the case is moot, it should apply the Supreme Court's Munsingware doctrine and vacate the lower court's judgment. Can you address that?
Yes, absolutely. Your Honor, Munsingware should only be applied in extremely narrow circumstances. This is not one of them. No one here has slept on their rights. Usually you apply Munsingware to prevent unfairness to the losing party, where there is an inability to address something that then binds them in a way that is a problem for them in the future.
Well, the unfairness argument, I guess, they complied, and now that renders the case moot because the poll was conducted.
And they chose not to file an expedited appeal, which they absolutely could have done.
But still, I mean,
well, and
let's just set that aside.
We're going to add a minute.
Oh, fantastic. A couple of issues, Your Honor. I would say that that there's had the expedited appeal occurred, of course, that would be a point in their favor, right? That would simply be another reason to consider the possibility that unfairness. It would also means that 344 would not have had an opportunity to be passed. The governor also agreed in the passage of 344, which clarifies effectual delivery, in addition to the fact that I think, Your Honor, that we should really be cautious about the application of Munsingware. Justice Jackson has written about this pretty extensively, noting that the case law that we have in the world is not merely the property of the private litigants, but it also belongs to the legal community as a whole. We need guidance. This guidance is not inconsistent with what the legislature has done in 344. And the fact that it might at some future time be applied in a way that forces the governor to ensure that a veto message is transmitted to the secretary is not a harm to the people of Montana, and it is not a harm to the governor.
What are you referring to?
In several dissents, she has brought this up when Munsingware has been applied. One example case that I have for you is Chapman versus Doe. This is 598 U.S., and we don't have the last part of the recorder number, 143 Supreme Court, 857, pin site 858, 2023, and that's Justice Jackson dissenting from a reversal that applied Munsingware, or not a reversal, but a vacator.
Thank you.
Yes.
Counsel, are you going to get to standing at all? Or is Mr. Black?
Mr. Black will address standing. I would love for just a moment to address the political question doctrine. It does seem rather important. Now, I want to address two cases very quickly, Nixon versus United States and Coate versus Omholt, which the governor's office raised. I did not think that these are cases that align at all with the Article 6, Section 10.4 scenario. So in Nixon, there is a federal judge who sues the Senate for failing to convene as a whole Senate to consider his impeachment, and instead doing it by committee. The provision at issue here says in the US Constitution that the Senate shall have the sole power to try all impeachments. That's a very clear delegation to the Senate to decide how they will try all impeachments. It doesn't apply here. That's not what's happening in Article 6, Section 10.4. And in fact, in Article 6, Section 10.4, only at one point is anything directed to the legislature. The legislature may reconvene as provided by law to reconsider any bill vetoed by the governor. Nothing else in Section 10 for all of Section 10 is directed to the legislature.
Except for
the special session.
Well,
Well, it absolutely does. And as we see in the case that is the Missoula, it's City of Missoula versus Mountain Water Company, a provision is self-executing when it can be given effect without the aid of legislation. It does not need legislation in order for this to be clear. We know exactly what the Constitution intends for the Secretary of State and the governor to do. They intend for them to facilitate the override process when the situation arises that necessitates it. And that situation is when the legislature is out of session when the veto occurs. And I understand that Justice Rice may see the question of when that 10-4A says when the veto occurs. And I think that's where the court has to look at the intent and has to consider that even in 1972, the delegates considered including a provision specifically that would allow copies of a veto to be sent from the governor to the legislators. That's where it becomes really important because it's the only way that you can understand the whole section. Otherwise, you don't give force to the intent that was expressed by both the proponents in 1982 and the delegates in 1972.
But the intent can't contradict what is the most superior evidence of intent, and that's the words on the page.
And absolutely, and I don't think that it does. I really don't think that it does, Your Honor. I think that receipt is essential, and that it must be the case that the legislature is aware of the veto before they can be held accountable to its existence. And I will make one final note and pass to my colleague. Your Honor, the governor regularly refers to the legislature's perspective on this lawsuit. The legislature has expressed no perspective on this lawsuit. Several individual legislators wrote a letter to this court and to the lower court and to the respective branches regarding their views, but the legislature knows how to participate in litigation. It knows how to enter as a body. It knows how to enter as a specific chamber, and each legislator knows how to write a declaration to be included expressing their perspective. None of these things occurred. I think that it's important to keep in mind that while the legislature's position is, of course, of interest, and specific legislators' thoughts and ideas are interesting to know, that the timing of that letter comes at exactly the moment when it becomes clear that the poll will occur. The legislature is in its zenith of power when it's doing the politicking of the legislature. There were people who were seriously against the passage of SB 442, and they took the opportunity to lobby hard against it, using those letters as one mechanism for doing so. That's not to suggest that they did anything wrong by doing that, but I will say it is a mistake to conclude that that is the legislature speaking to the court. It's not. With that, I will pass to Mr. Black.
Thank you. Good morning. May it please the court, counsel, members of the public, Mike Black on behalf of Montana Association of Counties. I am going to address primarily standing, but I want to raise one issue in response to Mr. Rice's or Justice Rice's concerns, and that is with respect to whether or not the legislature was in session. I don't think that there's any dispute that there's really no evidence in the record that this was actually delivered to the Senate before they did the motion for sine die. If you read the Northeast declarations very carefully, there was a veto, it was sent out to be delivered. There's no evidence that it actually was delivered prior to the sine die motion. But the most important aspect that I want to point out is that Article 3, Section 1 defines the legislature as both bodies.
How about this evidence from the legislative history? This does not address the issue we ran into. This is on the later bill, Senate Bill 344.
Okay.
In the last session where the veto was delivered prior to sine die.
But it was,
somebody certainly thinks it was.
It was prior to sine die of the House, but not of the Senate. And my point is, Your Honor, is that Article 3, Section 1 defines the legislature as both bodies.
Well, if the House is still in session, is the legislature still in session?
No, not entirely. It can only consider, and I know you were a legislator, Your Honor, and I was not. It can still consider business that was conducted by the Senate prior to them adjourning sine die, but the legislature as a body is no longer in session.
Okay.
By the House operates, that's a legislative day. Even if
Sure, a House legislative day, but I mean, there's nothing in the record or the law to indicate that the sine die motion was untimely or inappropriate in the Senate. And there's nothing in the record to indicate that the Senate was aware of this bill being vetoed prior to the sine die motion.
Of course, the Constitution speaks in language of the governor's action of vetoing.
I understand.
Not if that arrives, it's does the governor veto when the legislature is in session or out of session. That's the
I understand what it says, Your Honor, and I think that I would adopt, Ms. Summers Flanagan's assessment of that is that clearly the intent of the framers and on the 1982 amendment was to make sure that with respect to a supermajority bill that was passed, that polling the legislature is the remedy that's available on behalf of the entire public. And that gets me to standing, as long as I've addressed your concern.
Yeah, I want to pick up on that. So your council's last statement was, we don't know anything about the legislature. They're not here. They didn't express, they didn't act. And that's kind of why I'm wondering, why are interest groups here vindicating legislative powers that the legislature chose to vindicate by not exercising?
Sure.
Why do you have standing to do that?
That's a fundamental misunderstanding of the position of the plaintiffs and the petitioners in this case. The entire purpose of this case was to vindicate their own rights to participate in a process that's recognized by the Constitution. The Constitution provides, and we cite Article 2, Section 1 in the petition and the complaint, that the popular sovereignty remains with the people. And the entire structure and purpose of the Constitution provides that the people have the right to be involved in this process. There's nothing more fundamental than that. And there are a number of different provisions in Article 2 that give rise to this. Obviously, we've got the popular sovereignty. We've got the provision.
This wasn't an initiative. I mean, every citizen doesn't have a right to participate in the veto poll. Only the legislators do. So this is a separation of powers question, right? Power of the legislature to override a veto in the lawmaking process. Citizens don't have a right to a passage of a specific bill. So the citizens can't, I guess I'm trying to figure out why citizens can force legislators to do an override poll that they didn't request.
Well, we're not asking the legislators can decline to respond to the poll. They could vote no. The whole purpose of this is to give the interest groups the opportunity to essentially petition the government for redress of grievances. I mean, that is an article. I mean, I can go through all the other articles, and I think it's Article 23 where they reserve things that aren't conveyed to the legislature. And
keep going.
Okay, but the most important of this, if you want to put the finest point on this, is the right to petition the government for redress of grievances. It's arcane language. It goes back to the Magna Carta, for gosh sakes. Gives us the opportunity to participate in a government process with respect to public policy and public import, and specifically a process that's recognized by the Constitution, and that is the polling of the legislature under these specific circumstances on an override veto. These parties have that right. It's a civic right. We raised it a number of different times, but the finest point to put on it is Article 2, Section 6, where you petition the government for redress of grievances.
How does your interest, your client's interest, differ from the interests of every other citizen?
Well, in some respects they do, Justice Baker. In some respects they don't. But I think that's the lesson we learned from Schoof and from Held and that line of cases. Just because everybody else is harmed doesn't mean that we're not harmed. A widespread harm does not preclude us from having standing. But in this particular circumstance, it's clear that the parties before the court, the petitioners and the plaintiffs, were involved. They were invested in this. They are the ones who pushed for an override veto polling by mail. They're the ones who were lobbying for this legislation. They were the ones who were working with the legislators. And they were vested in whichever procedure is used to try and override the veto. They wanted the opportunity to petition their legislators and work publicly to try and influence the legislation. And so it's particularized and generalized. So it's a little bit of both, but I don't think that we need to have a particular interest separate from the public, because that's what we recognized in Schoof and Held, and I think Heffernan is another case that they did that. So,
Mr. Black, can you, I guess, when we have, I mean, we've got to root it in something. So rather than just say generally the right to participate and popular sovereignty, I mean, can you articulate a path for us going forward where we're saying that they're standing to raise this constitutional issue?
Your Honor, and I appreciate that question. It's a really good question. And part of it goes back to the decision you wrote in Board of Regents versus Knudsen, where we talk about what is the nature of legislative power. The Constitution does not empower the legislature. What it does, in a sense, is limit the power of the legislature. And if you look at a number of different constitutional provisions, and I mean, the popular sovereignty provision, the self-government provision, Article 2, Section 2, the right of participation, Article 2, Section 8, even though it's directed to agencies and not the legislature, the right to know, Section 7, freedom of speech, but very particularly, you know, the right to petition the government for redress of grievances is part of this. And if we look at, it's the catch-all provision, I want to say it's Article 2, Section 23, where the people reserve what they haven't conveyed to the other branches of government under the Constitution. We have the right as citizens, whether it's through the associational context for standing, to petition the government to ask for input on matters of civic concern. And that's fundamental to everything there. And so I understand your concern, but I think that what we have to look at is just the structure of the Constitution and what it's designed to do. And if we, and I will cite the Gearing case because it actually does a really nice job. It actually came up once, and it's Gearing versus the members of the 1993 legislature, 269 Montana, 373. The page site is 375. It's a 1995 case where this court recognized that there is the right to petition the legislature for redress of grievances, and it had to do with the legislature allegedly violating the Constitution with respect to setting their own compensation.
So you're really, that's a pretty strong leap. I mean, we have not really gone as far as what you're describing.
But Your Honor, I don't think you've had the opportunity to either.
That's true.
I mean, and so, I mean, this is a unique case, and you know, and I want to get off in the weeds about the right to petition the government for redress of grievances, but it's really interesting if you look at.
I'm talking more about the limited nature, the reserved rights.
Sure, sure.
We don't have much on that.
You're right, Your Honor, and you know, I'm not here to offer you an opportunity to go off and do things that aren't before you. I mean, obviously you decide the questions that are before you. But if you go back and look at First Amendment jurisprudence, and we're on this. And
we're over time, so.
Okay, I want to cite one case to you for your consideration if you want to do it. It actually summarizes the First Amendment jurisprudence that the Supreme Court of Colorado did a nice job on it about 40 years ago. It's called Protect Our Mountain Environment, Inc. versus District Court 677 Pacific 7 1361. I think they just talk about how important the right to petition the government for redress of grievances is and summarizes. So I think I'll just, in conclusion, Your Honor, I think that what we have before us today is just the opportunity to vindicate the people's rights as carefully built into the veto provisions of Article 6, Section 10, to participate in the veto override process. This is a process recognized by law. I think our citizens, including my client and Ms. Riley Summers Flanagan's client, have the right to participate in that process as a civic right under the Montana Constitution. So unless there's more questions, I'm happy to sit down. Thank you.
Just a few points in rebuttal and of course, answer any questions that you have. Mr. Black and I agree on one thing, and that is that we need to respect the structure of the Constitution. The petitioners don't identify anything that the governor should have done differently, at least that's provided for under the Constitution. He signed or vetoed the bill when the legislature was in session, returned it to the legislature. There was nothing else he could have done. what this case is about is notice, and you heard that multiple times through the course of my friend's presentation. That's not for the governor. That's certainly not included in the text of Article 6, Section 10. There's no way. I mean, it's you can imagine the governor's supposed to, when he sends the veto, call and make sure it got there okay. I mean, if it didn't get there okay, they'd send it back. They'd let the governor know. That's what is required. And Justice Rice, you mentioned, you cited a quote, and it was from Senate Minority Leader Flowers. He was at the Senate, it wasn't at the House. And he said, yes, we received it while the legislature was in session. The letter addressed to this court and to the governor and secretary of state, signed by 26 senators. Let me note, all of whom, every single one of whom voted for SB 442, said we received it while the legislature is in session. It's the plaintiff's burden to prove their case. They never marshaled any facts to suggest that the legislature didn't receive the bill, the vetoed bill, while they were in session. When you have when you have sort of amorphous, ambiguous interests, you get amorphous, ambiguous facts. That's one of the reasons we have standing provisions and require parties to have concrete facts, concrete injury, so they can bring concrete facts to the court. This isn't about petitioning the government for grievances. They can petition the government. They were petitioning the government through the legislative process. They don't have a right to involve themselves in the veto process that the legislature, that the Constitution leaves to the political branches. I'd like to address 344. The statute is a bit of a chore to get through. I think our position is that it does not apply to this situation. We think the legislature, when they passed it, was clear that it was related, but didn't address this issue. Even if it did, it wouldn't have changed anything. I mean, it doesn't require the governor to give to notify every single legislator that he vetoed it. It requires him to send it back to the legislature in a specific form, and it only requires that one of the bodies be in session. So if that were the case here, the House was unambiguously still in session, so it wouldn't have resolved the issue anyway. And I think why it's important, like I said in my introductory remarks, even if it applied to adjournment sine die, and my friends don't address this question, the district court's decision stands as an obstacle because it's a decision interpreting what the Constitution requires, and there is no way to reconcile what the district court said and what in 344.
Sorry, I
keep doing that.
Go ahead.
Well, except while Montana argues that 344 changed the landscape so much that we don't have the same pattern.
Well, I don't.
Do you remember that part of her argument? And I guess if you could address that.
I don't think it does because the governor vetoed the bill when the legislature was in session. Subsection B remains unchanged. It wouldn't have changed a thing. Or subsection or 2, I guess it would be. So I don't think it changes the landscape. And our first argument is that it only applies to adjournment for the day, not for the session. And so I don't think it didn't apply when this case was going on. And I think the legislature would have been more clear and would have addressed this issue head on if not for the district court's decision. I think that is an obstacle to resolution of that issue.
So could you just briefly address how you view your position vis-a-vis the secretary's argument in terms of the mandamus and giving some guidance to the secretary, how that fits in with what you're arguing we should do?
I think it fits in. I think our arguments are consistent. I think mandamus is a problem. We made this argument in our brief that mandamus wasn't appropriate because.
Do we address that?
I think as a prudential matter, I think the court could address the issue under the public interest exception. It would be a little bit of a little bit more unusual, but I think the court could address this because this is an issue that needs guidance from the court and whose authority is it, and what is the authority of the governor and the secretary of state and private parties. Honestly, it's a little bit hard for me to see past standing because I think it is a matter of justiciability. But I do think that the court has in the past addressed issues that under the public interest exception that need resolution. And let me talk about that for just a moment, because you've raised the Munsingware issue, and I realize that this court hasn't applied Munsingware. I think it's our fallback argument. It's not our preference. We think that because of the public interest exception, that the court should address the broader issue, especially of standing. And those two doctrines coexist in other jurisdictions. The courts have applied the public interest exception, even if Munsingware just simply vacating the district court's decision would resolve the issue. In fact, in Ramon v. Short, that's the immigration detainer case, the court could have just vacated the district court's decision. It answered the issue and applied the public interest exception because public officials needed guidance. And I think that's right here. But aside, if the court were going to find that the issue is moot, it should, without doubt, vacate the decision. There is, every litigant gets the right to an appeal, and if there is no right to an appeal at no fault of that party, then the judgment should be vacated. That's why Munsingware exists. I haven't read the dissent from Justice Jackson. I think there's a reason it's a dissent if it applies in this, to this sort of set of facts. Munsingware is well established. It's applied by every circuit in the country and it's a United States Supreme Court case because equity demands it. Unless there are any more questions, we would ask that you reverse the district court. Thank you.
Just a couple of points to make. My friends surprised me a little bit by the dispute as to whether the legislature was in session or out of session, because the court below did not tangle with that, and the record's pretty established on one side and there are no facts on the other. But I just want to make 2 points. One, when the legislature is in session, they have 90 days. If only one chamber is meeting, that day counts against the legislature. House meets, Senate doesn't. The Senate has one less day. Number two, it would lead to an absurd result to hold that the legislature is not in session if the Senate has sine die, because it would put all of the bills that the House voted on later that day in question. Number two, let's talk a little bit about Senate Bill 344. I think what my friends forgot is that the lower court's decision talks about an independent obligation of the secretary, and that obligation was based on whether or not the legislature knew at the time that they voted to sine die that the bill had been returned. And so regardless of whether there is a recipient that is dictated by statute as to who the governor is to deliver it to, the constitutional interpretation by the district court remains that the Secretary of State has an independent duty to make that decipher, which Senate Bill 344 does not address. A few of the points related to mootness and standing, I do want to emphasize that both parties filed stays in this case. We wanted to address those types of merit obligations, and it would be very difficult in our American system to have a party do everything that they can to comply with the court and respect the court and ask the court, and to then be put in this untenable position. There are no discovery made below related to that delivery, and so that goes to why mandamus was not appropriate. And in fact, to the extent of the argument that declaratory relief is inappropriate, well, if declaratory relief is inappropriate in the situation, clearly mandamus isn't. Chief, do I have permission to?
Real quick.
Real quick. I think, lastly, I'll say this. It is the province of the judiciary to interpret what the law is, but not what the law should be. And below, the court said what the law should be. This court has an opportunity to show that interpretive powers can also be restraint where it is inapplicable, and to show Montana that the separation of powers is alive and well, because just as though the mootness exception applied in McLaughlin, the judiciary is not only protective of its own powers, it is equally as protective of the executive and legislative branches' powers. And for those reasons, we'd ask you to reverse, and to echo, it's been an honor of a lifetime to stand before you. Thank you.
Thank you. Counsel, the case is submitted. We should give a brave round of applause. Sir.
And nice job, everybody.
Everybody, the lunch buffet will be available out here at 11:15, and then we will be on time for our keynote at noon. Thank you.